Hi folks, and welcome back to Contract A videos. This week is week 1 and we are looking at theory. And before I hear the groan and see the pained look in your face, I actually think theory is a really useful thing to look at first up. It's a kind of nice bookend for your degree program because we take a little very tentative look at theory today, just dip our toe into the water, so to speak, but then you follow up on theory much more in-depth and in a far more satisfactory fashion in jurisprudence. So you kind of start off just a little tiny bit now and then you really look at the whole thing in detail much later. But today's really just an entree into theory, as it were. So without further ado, let's have a look at the Prezi for this week. So firstly, we're going to have a little look at theory and its role for us as lawyers. And then just two little, thought bubbles at the end of this week's video. And they are basically, well, okay, where does that leave us? Where is contract law in the grand scheme of the legal universe? And secondly, a little bit more nuts and bolty, if that's a phrase, what's the roadmap for us in contract law? How will these two units meld together? What are we going to get out of it at the end of the day? Okay, let us look at theories. Okay, so theory. I have posted a little teaser on Moodle and Facebook for you, proposing that theory was in fact a waste of time. It was a little facetious of me because I actually don't think theory is a waste of time, and neither does the LPAB or the LAC, the standards bodies that require us to look at the content in a law degree. Theory is actually required as part of contract law, and it makes sense, as I said just before, not just in terms of looking at a little bit of theory now and a lot of theory later in jurisprudence, but there is a sound reason why we need to have a little look at theory in contract law. Now, before I hear you say, okay, we've got to push through this, I actually think theory is, wow, that came out louder than I thought. I actually think theory is a pretty interesting part of contract law, and it's part of what feeds in at the really pointy end of things when judges are having a hard time. And for that reason, it's useful as a kind of comfort blanket for judicial decision making in times of perhaps stress. So before we push into theory, let's have a look at what makes good theory. Okay, so for those that have had a little look at the nice PowerPoint that I've put up on Facebook, I'll pop it up also onto Moodle for you. It's not essential reading or anything like that. It's just a little set of PowerPoint slides that I found on the web. That help us think a little bit about what theory is and what theory does. Basically, there are a whole lot of super complicated and seemingly random phenomena out there in the world. And the nature of human beings is to try and make sense of it all somehow. How do you make sense of a problematic, possibly, and seemingly random cluster of events or phenomena, things? And theory is like a system of ideas or a framework that helps us to kind of rationalize and work out, to understand what's going on in amongst all of these little disparate factors, events, things. Now, technically, theory in terms of the scientific disciplines tends to exhibit certain factors that we should think about. So if it's going to be a theory, it has to be falsifiable. That is, you should be able to prove that theory false. And that is what scientific theorists try to do. They come up with a theory, they say, this could be a possible explainer for what's going on, and then they pitch cricket balls at it until it falls over. Okay, now once it falls over, obviously it's been disproved, and you've got to come up with a new theory to try and explain that set of events. Okay, if you can't disprove a theory, then it's not really a theory, because a theory is going to be either true or false, so far as scientists are concerned. Okay, so if it can't be disproved, it's really a philosophy. Okay, and I think that's probably technically where you'd put most legal theory. But anyway, in terms of theories, what are the good qualities that you should have in a theory? It should be simple. Okay, there's no point coming up with this ladder that has 53 steps just to get up 10 centimeters. Okay, you want something that's nice and simple, 3 steps and you're there. Okay, or 2 or 1, even better. You want to have very few internal contradictions in terms of your theory. It should logically proceed according to its own terms. Okay, it should be verifiable, and that's the flip side of the falsifiable point. It should be elegant. Okay, symmetrical, simple, accurate. If you can combine all of those factors together, you've got something that's fairly beautiful. E equals mc squared, for example. Should be as general as possible to encompass an explanation for as many of those disparate things as possible. It should have few or no anomalies, so things that don't fit into the theory. Okay. The goal, and that leads me to this point, is the explanatory power of a theory. How good or how not so good does a theory actually work to explain what it purports to explain? If you're going to have a whole heap of exceptions to that theory, then it hasn't got a whole lot of explanatory power, what scientists would call explanatory power. So as I said before, legal theory probably doesn't cut the mustard so far as scientists are concerned anyway. They would probably call it philosophy, or it's been called a whole heap of other things: rational reconstruction, philosophical foundations, constructive interpretation. So legal theory, when you think about legal theory, it's not really theory at all, but it's about as close as lawyers get anyway to the scientific game of theorizing. All right, so what makes theory relevant to us? What makes it exciting? Actually, that's probably overstating the case. What makes it interesting for us as contract lawyers? There's a couple of reasons why. Firstly, it's just a generally satisfying intellectual exercise. It's what humans do. We like to make sense of things. And if we can see patterns in a whole heap of otherwise disparate events, then it kind of makes us happy. Because I'm happy. But apart from all of that, apart from generally adding to our happiness, it's particularly useful for contract lawyers because contract law, unlike other areas of law like tort law or criminal law that predominantly rely on legislation for legal authority, contract law relies on the common law. And the common law, or judge-made law rather than parliament-made law, is all about the system of precedent, the doctrine of precedent. One case following another case and following another and another and another. Now, generally speaking, a case will only really be bound to follow precedent if there are similar enough facts to warrant the similar principles being applied. Okay, but what about those hard cases that judges encounter where the facts aren't terribly similar, or you have a completely novel set of facts or a novel circumstance that means that the previously developed body of principle doesn't squarely fit with what's going on in this particular case, And in those kinds of situations, you'll often find judges searching around and looking through theory to try and assist them in their judicial decision making. And that's precisely where we see Dawkins and Moore kind of pitching their arguments about, the analogies that you can make in terms of theory and what judges do. There's a nice little tussle presently going on in the UK courts with Mr. Justice Leggett in the High Court, fairly openly embracing relational contracting principles, being beaten down occasionally, but popping up to give the whole thing a go again. I put up a couple of articles for you in case you're interested in that. We'll look at relational contracting later on in this video. But theory is part of what can assist us as lawmakers, as lawyers that are interested in contract law, in terms of keeping the doctrine consistent and logically compelling. So that's my best pitch as to why theory is interesting for us, or should be. Perhaps you can tell me if I've convinced you at the end of the video. You can argue with me in the Zoom. And the first theory I want to get our collective heads around is the classical theory. This is the big behemoth that we need to confront because it is and has been dominant for about 150 years now. The contract basically represents the will of the parties. So this theory runs, we need freedom of contract with minimal state intervention. The rationale for the classical theory is that we'll all do better if we bargain for ourselves and pretty much the state leaves us alone. Okay, bargain for ourselves. We do what we want, what we will. The background obviously is it's very heavily tied into the will theory and economic theory. And given that economic theory has been so influential pretty much since the 80s, it really does mean that this classical contract theory is very, very heavily entrenched in legal minds, and particularly in terms of judicial decision making. Rose to prominence late 19th century England. Liberal individualist theory. So the hallmarks here are individualism, self-reliance, and exercise of free will over state intervention. Why is it important? Obviously, contract doctrine's heady days were in the 1850s onwards in England, and that was precisely the time that the contract law was imported into Australia from England in terms of our settlement, and it still continues to be a very heavy influence on Australian lawmaking to this day. What are the hallmarks? Contracts are an exercise of individual free will, as I said before. What makes contracts binding is because the parties have freely, of their own volition, entered into those particular arrangements. So they've taken on those arrangements because they want them, all right? They've been freely bargained for. There's a little bit of an economic undertone creeping in there. They've been freely bargained for. They represent economic optimism. So basically the world would all be a better place if we had contract law representing a balance between the will of the many, the good of the many, so utilitarianism kind of focus, and purely rational self-maximizing activity. So pure opportunists at one end and altruists at the other end. Contract law is kind of the middle of the seesaw, okay? And where we should give as much free rein to free will as we can, and as little state intervention as we can, and that is where contract law should sit. It involves freedom to contract, that's your free will component, and it also involves freedom from contract, that is having obligations imposed on you by the state. Okay, freedom to contract, freedom from contract. Just freedom.
But they'll never take our freedom!
Okay, yay. All right, enough silliness. One of the criticisms that have been levelled against the classical contract theory, well, many over the years, but predominantly the very fundamental issue is that not all contract terms, nor all contracts actually themselves, are a result of a freely bargained, negotiated position reflecting the will of the parties. Okay, there will be cases where courts need to use objective tests when they are assessing what the will of the parties is. And those objective tests are seen in things like where a court is trying to work out whether a contract has been formed. They don't actually try and forensically discover what the subjective intent or will was of each of the parties involved. What they do is they look at the situation from a bystander's point of view, and they say, what would the reasonable person conclude? After looking at all of the facts of this particular case, what would a reasonable person say? Has a contract been formed or not? In terms of looking at the content of a contract, what the terms say, how the terms should be construed. Again, an objective point of view will be taken by the court. What was objectively agreed? How did the parties seem to indicate to a third party what they have agreed in this case? Oftentimes also there are lacunae, what a great word, in contract terms. There are things that have been left out or omitted. Here, a court will have to work out what the actual content of a contract is, and they'll have to fill the gaps. How do they do that? By implying terms. Once again, the court then needs to work out, well, what would the parties have intended in this particular case? So implied terms, there is a whole stack of principles that go with implied terms, and we'll look at that later on in the term here in Contract Law A. The other problem with the classical contract theory is that not all contracts are freely negotiated. Obviously, all of us enter standard form terms and conditions pretty much almost every day, where you are looking at buying something from any party pretty much that has corporate power, phone contracts, internet contracts, even buying a car, getting finance. Mostly the ball is out of your hands when it comes to negotiating terms. You will be presented with a contract. You might read it, you might not, you might just sign on the dotted line. Obviously there's no negotiation that goes on there. It's pretty unlikely that that particular contract is going to reflect your will apart from the end game of what the contract actually achieves for you, and that is what you're getting transferred to you under that contract. There will be an asymmetrical power relationship there, and that's largely swept under the rug so far as the classical contract theory is concerned. So the people that generally tend to pick apart this theory in terms of the standard form issue, asymmetrical power dynamics issue would be people like the critical legal scholars that you would have read in Patterson. The state obviously also doesn't really leave us untouched and give us complete free rein to choke ourselves so far as setting contract terms goes. There are limits to what you can do, and public policy often steps in to do things like striking down offensive terms. In Contract B, you'll look at penalty clauses, the imposition of penalty damages where one party is trying to bind the other party into contractual performance in terrorem. So they'll include terms like, you will pay me $1 trillion, is that even an amount, in damages if you breach this contract. Penalty clauses like that, the courts will just say, sorry, no, we'll just strike that down. It's offensive. People shouldn't be allowed to do that stuff. The bottom line, and that segues nicely, one of the principal criticisms of classical theory is that it tends to leave out ethics and the role for things like public policy. It's kind of out of the picture here, and that's largely as a result of, if you think about it, where this theory grew out of a very liberal, individualist kind of aligned theory. You've got to give the parties what they want in terms of enforcing their will. You look at a contract with that goal in mind. What's on the paper, that's what reflects the will of the parties. That's what we should enforce. There are some holes in it, but there are in most contract law theories. So that's the classical contract theory. And that's where we'll leave it for this particular video for week 1, and hold that thought. We'll come back to part 2 and we'll look at promise theory. Thanks, guys.